5:47 a.m., June 12, 2026, Houston, Texas. 14 FBI vehicles moved through the pre-dawn darkness of the Harris County Industrial Corridor, headlights off, engines throttled low. 3 columns, 2 targets, 1 timetable. Estimated value of the transactions under investigation, $4, $2 million. Routed through 3 shell companies that, on paper, did not exist in any meaningful sense of the word. The lead vehicle stopped outside a nondescript 2-story office building on Beltway 8. Pale brick, tinted windows. A sign near the entrance read, Gulf Coast Trade Partners, LLC. No lights inside, no vehicles in the lot. The building looked exactly like what it was supposed to be. An ordinary commercial office, the kind that lines every ring road around every mid-size American city. It was not ordinary. Inside, according to warrant applications filed in the Southern District of Texas, were servers, ledger books, and records documenting a payment network that federal prosecutors would later describe as one of the first financial enforcement cases directly tied to the 2026 Strait of Hormuz crisis. 3 shell companies, 3 layers of foreign intermediaries, and one man at the center who, by all available accounts, had been doing this for months without a single flag reaching the right desk. Until one did. The second convoy, 7 vehicles, turned onto a residential street in Sugar Land, 22 miles southwest. A brick colonial with a 2-car garage and a satellite dish on the roof. No lights on. A white sedan in the driveway. The tactical team stacked at the front and rear entrances simultaneously, checking synchronized watches. The signal would come in 4 minutes. What no one had anticipated when the investigation started, 8 months earlier, was how much of the network would eventually be visible from a single wire transfer flagged by a bank compliance officer in December 2025. 1 transaction. $47,000. Routed through an account registered to a company incorporated 11 days prior. That transaction opened everything. The story begins not in Houston, but in a FinCEN advisory issued quietly in early November 2025, shortly after USS. Naval assets began positioning near the Strait of Hormuz. The Financial Crimes Enforcement Network had identified a cluster of overseas accounts, primarily registered in the UAE and Oman, showing patterns consistent with Iranian sanctions evasion. Wire transfers split into amounts just under reporting thresholds, sequential routing through multiple jurisdictions within 72-hour windows, beneficiary accounts with minimal business history. The advisory did not name names. It described behavioral signatures, and it went to every major financial institution in the country. Most compliance desks processed it and moved on. At a mid-size regional bank in Houston's Galleria area, one compliance analyst did not move on. Her name does not appear in any public record. She flagged 3 incoming transfers, each under $50,000, each arriving within a 4-day window, each originating from a currency exchange platform registered in Dubai. The receiving account belonged to a Texas LLC incorporated 2 weeks earlier, Meridian Gulf Services. She submitted a suspicious activity report on December 3, 2025. Standard procedure. The report entered the FinCEN system, where it sat for 11 days before being assigned to a financial analyst at the FBI's Houston field office. The analyst pulled the corporate registration for Meridian Gulf Services, Harris County Records, filed November 19, 2025. Registered agent, a law firm with an address in the Greenway Plaza district. The LLC listed no employees, no physical office, no stated business activity beyond international trade consulting. Its operating agreement was 3 pages. The signature on the document belonged to a man named Farid Rahimian. What struck investigators immediately was a detail that shouldn't have been there. The contact phone number listed on the state registration, a number that was supposed to belong to the law firm's registered agent, traced back to a prepaid device purchased with cash at a convenience store near the Port of Houston in October 2025, a registered legal entity. With an untraceable phone number, filed 5 weeks before the wire transfers began, that number couldn't exist in a legitimate business structure. Not without a reason. I spent a lot of time going through the sequence of early discoveries in this case, and what stands out isn't the sophistication of the concealment. It's how close the whole thing came to never being noticed at all. 1 compliance officer, 1 SAR, 11 days in a queue. The margin between discovery and invisibility was measured in administrative workflow. The FBI opened a preliminary inquiry on December 14, 2025. 3 analysts were assigned. Within a week, they had identified 2 additional LLCs with patterns nearly identical to Meridian Gulf Services. The second company, Coastal Bridge Imports, LLC. Incorporated December 2nd, 2025, 3 days before the first SAR was even filed. Registered in Harris County. Same registered agent law firm. A different signature, but the same structural template. No employees, no office. Stated business, freight coordination and logistics support. The third company, Harborview Exchange Solutions, LLC. Incorporated January 6, 2026. The newest of the three. By the time investigators found it, it had already received a single transfer of $890,000. 3 companies, formed across a 9-week window, all registered through the same law firm, all with no verifiable business operations. Combined incoming transfers as of January 2026, just over $1, $4 million. But investigators quickly realized they were looking at an incomplete picture. The transfers that had landed so far were not the full amount. They were installments. The network was still active. What's most surprising about this case isn't how much money moved. It's how little infrastructure was needed to move it. 3 LLCs. A law firm that asked few questions. A currency exchange platform in Dubai that processed transactions without triggering SWIFT-level scrutiny. And a freight logistics company in Oman that served as the midpoint layering entity. The pass-through that made the money appear to originate from commercial shipping activity rather than sanctioned sources. The Oman entity was called Al Nakheel Maritime Services. It had a real business history. Registered in Muscat in 2019, it had processed legitimate freight invoices for years. Investigators later concluded that Al Nakheel's involvement was not coincidental. The company had been deliberately selected as a layering vehicle because its legitimate transaction history provided cover. Payments arriving from Al Nakheel's account looked, at first pass, like routine shipping settlements. The Dubai Currency Exchange, which federal filings identify only as a UAE-registered financial services platform, handled the first conversion step. Funds originating from overseas accounts flagged in the FinCEN advisory were converted and retransmitted as what appeared to be commercial payments for freight services rendered. By the time the money reached the Houston LLCs, it had passed through 2 jurisdictions, 2 entities with surface-level legitimacy, and at least 3 account numbers that would each need to be separately subpoenaed. Farid Rahimian was the thread connecting all 3 receiving entities. A naturalized U.S. citizen, he had operated a licensed import brokerage in Houston for 11 years. Gulf Atlantic Import Group, a real company. Real clients. Legitimate business with the Port of Houston going back to 2015. He had a warehouse lease in the Manchester neighborhood near the ship channel. A comptroller, 2 administrative staff, and a relationship with a freight forwarding company in Oman that predated the scheme by several years. That legitimate business history was the architecture of the cover. The shell LLCs were not meant to stand alone. They were meant to funnel funds into an ecosystem where Rahimian's real business provided plausible context. Money in through the shells. Transferred out through transactions that, on paper, resembled intercompany service settlements. End result: dollars available to purchase tanker fuel for Iranian-linked shipping interests attempting to operate despite the blockade's financial pressure campaign. The United States had imposed secondary sanctions on entities facilitating Iranian oil transport in January 2026, following the naval positioning in the Strait of Hormuz. Any entity, domestic or foreign, that processed payments enabling Iranian shipping operations faced potential liability under IEEPA, the International Emergency Economic Powers Act. Violations carried sentences of up to 20 years. Rahimian, investigators concluded, understood this. He also believed the layering structure was sufficient to obscure the origin and purpose of the funds. He was wrong about that. But he was right about one thing. The structure had already worked 4 times before anyone caught it. Here's the part that doesn't sit right, even now. The first 4 transfers totaling just under $1, $4 million cleared without interruption. They processed through legitimate banking rails, landed in accounts held by entities with valid EIN numbers and state registrations, and generated no automatic flags beyond the 1 SAR filed by the compliance analyst who happened to be paying attention that week in December. The system's automatic safeguards caught nothing. A human did. FBI agents assigned to the Financial Crime Squad formalized the investigation in January 2026, bringing in OFAC, the Office of Foreign Assets Control, as a coordinating agency. OFAC has specific jurisdiction over sanctions enforcement. Its analysts had already been tracking the UAE currency exchange platform in connection with separate Iranian sanctions evasion activity. The coordination between FBI Houston and OFAC Washington defined the pace of the investigation. Subpoenas for foreign financial records required additional legal process. Mutual legal assistance treaty requests to the UAE and Oman governments were filed in February 2026. The response timeline was measured in weeks, not days. Meanwhile, agents maintained passive surveillance on Rahimian's warehouse and office locations. No physical entry, no contact. Surveillance teams documented his routine, his associates, his vehicle movements. A second subject entered the picture in late February, a man identified in court filings as Hamid Khalvati, a freight forwarding consultant with ties to both the Oman Logistics Company and a second UAE-based entity not previously identified in the FinCEN advisory. Khalvati's involvement expanded the picture significantly. He was not a U.S. person. He traveled on an Omani passport and had entered the United States twice in 2025, once in September, once in November. Both times on a B-1 business visa listing the purpose of travel as freight consulting. His November visit coincided, within a 9-day window, with the incorporation of Meridian Gulf Services. Investigators now had two subjects, 3 shell companies, a foreign layering network spanning 2 Gulf states, and a financial trail that, once the MLAT responses came back in March 2026, turned out to be considerably larger than the original $1, $4 million in documented transfers. The Oman MLAT response, received March 18, 2026, revealed that Al Nakheel Maritime Services had processed outgoing transfers to the 3 Houston LLCs totaling not $1, $4 million, but $3, $1 million across 7 separate transactions, 5 of which had not yet been captured by U.S. banking surveillance because they had cleared through a correspondent banking chain that routed through a European intermediary before reaching domestic accounts. The full picture, $3, $1 million already received. Investigators estimated an additional $1, $1 million in the pipeline based on transaction scheduling patterns identified in Al Nakheel's internal records. Combined total, $4, $2 million. That number, once confirmed, drove the investigation into its operational phase. Put yourself in the position of the lead case agent for a moment, sitting across from the MLAT documents in March, doing the math, realizing that the network had already successfully moved 74% of its total intended transfer volume before the investigation even had its first confirmed foreign financial record. The warrants couldn't come fast enough. But moving too early risked alerting the network before the full picture was documented. The team made the call to hold. 4 more weeks of evidence gathering. The risk being that the 5th transfer, the one prosecutors later confirmed was days away from processing, would clear before they could stop it. 3 months of surveillance had produced the behavioral baseline. Rahimian's routine was predictable. He arrived at the Manchester warehouse between 8:15 and 8:45 a.m. on weekdays. He worked from the office on Beltway, 8 on Tuesday and Thursday afternoons. He communicated with Khalvati via an encrypted messaging application. But the metadata of those communications, obtained through lawful process from a domestic carrier, provided timestamp patterns consistent with the financial transaction scheduling. An obstacle surfaced in mid-April that threatened to compress the timeline. A routine review of Khalvati's travel records indicated he had booked a return flight to Muscat for April 29, 2026. If he left U.S. jurisdiction before warrants were executed, the government would lose direct access to a key subject. An emergency meeting between FBI Houston leadership, OFAC General Counsel, and the U.S. Attorney's Office for the Southern District of Texas produced a decision: accelerate the warrant preparation. The application package was submitted to the magistrate judge on April 21st. Approved April 23rd. Khalvati's flight was booked for April 29th. Agents placed a travel watch on Khalvati. He would not be arrested at the airport. That would tip Rahimian. But if he attempted to depart before the warrants were ready to execute simultaneously, the timetable would collapse. In the end, Khalvati delayed his departure by 3 weeks for reasons that remain unspecified in public filings. The warrants held. The countdown continued. The thing about this case is that it wasn't supposed to be this complex, this fast. What started as a single SAR from a regional bank compliance desk had, within 6 months, expanded into a multi-agency sanctions enforcement action with international legal cooperation, 3 foreign jurisdictions, and a subject list that grew from 1 name to 3 formal defendants and 2 additional individuals under review. That's not the exception in federal financial crime investigations. Increasingly, it's the baseline. What this tells us about the post-2026 sanctions enforcement landscape matters. the same financial infrastructure, the U.S., built to track terrorist financing after 2001, is now being retasked for a different kind of adversary. State-linked entities using commercial cover to blunt the economic pressure of a military standoff. The tools exist. The question is whether they're being deployed fast enough. Warrant preparation in May 2026 was meticulous. The search package covered 5 locations: the Beltway 8 office, the Manchester warehouse, Rahimian's primary residence in Sugarland, a secondary residence in Pearland listed in his wife's name, and a storage unit in Pasadena leased under the name of Coastal Bridge Imports LLC. The arrest warrants covered 3 individuals: Farid Rahimian, Hamid Khalvati, and a third subject, a Houston area accountant named Darius Mostagimi, whose role had emerged from the financial records as the person who maintained the internal ledger system documenting the shell company transactions. Mostagimi was a certified public accountant with his own firm and no prior criminal record. His connection to the scheme was financial and operational. He had maintained bookkeeping records for all 3 LLCs, records that, according to the warrant application, contained transaction logs for not only the 7 confirmed transfers, but 14 additional transactions flagged for further review. The full scope of what Mostagimi knew, and when he knew it, would become a contested question at trial. Unpopular opinion. The decision to charge Mostagimi as a principal defendant rather than pursue a cooperation agreement first was aggressive. The government had significant leverage. A CPA with a clean record, facing 20 years under IEEPA, would have been a highly motivated cooperator. The prosecution chose a different path, one that risks a longer trial timeline and gives the defense a sympathetic figure to work with. That calculation may prove correct, but it's not the obvious one. June warrants were assigned for simultaneous morning execution. The tactical element: 12 agents from the FBI's Houston SWAT component, supplemented by 2 additional investigative teams, began pre-positioning at 4:30 a.m. on June 12th. The Beltway 8 office hit first at 5:47 a.m. 6 agents entered through the front entrance after the building manager opened the lobby under a federal order to assist. No resistance. The building was unoccupied. Agents moved floor by floor, photographing and cataloging before touching anything. In the second-floor office suite leased to Gulf Coast Trade Partners, one of the shell entity names, they found 3 desktop computers, 2 external hard drives, a fireproof document safe, and a filing cabinet containing physical records. The safe was removed intact for forensic opening at the field office. The Manchester warehouse, 7 agents, a different approach. The facility was active, a legitimate freight operation, separate from the shell entity structure, with an early shift that had started at 5 a.m. Agents secured the building, identified warehouse staff, and directed them to a waiting area while the search was conducted. The target area within the warehouse was a partitioned office space in the rear, accessible through a separate locked door. Behind that door, a secondary server rack, 2 laptops, and, stacked on a metal shelving unit in bankers' boxes, physical documentation that agents later catalogued as spanning more than 300 pages of transaction records. The Sugarland residence was the most operationally sensitive location. Rahimian was inside, his wife, 2 children. The tactical team stacked at the front and rear simultaneously and executed a knock-and-announce entry at 5:51 a.m. Rahimian came to the door in civilian clothing within 40 seconds. He was detained without incident in the front hallway. His wife and children were directed to the kitchen. Rahimian said nothing beyond requesting an attorney. He was placed in federal custody and transported to the downtown detention facility. In the master bedroom closet, $310,000 in bundled U.S. currency. In a safe behind a false panel in the home office, an additional $70,000 and 3 prepaid mobile phones. Total cash seized at the Sugarland residence, $380,000. The Pearland secondary residence, no subjects present. Search produced financial documents and a laptop. Khalvati was located at a hotel near George Bush Intercontinental Airport. He had checked in 2 days earlier, apparently preparing for his rescheduled departure. Agents executed the arrest warrant at 5:53 a.m. Khalvati was in bed. He complied immediately. He was transported separately from Rahimian. Mostagimi was arrested at his accounting firm's office in the Westchase district at 6:04 a.m. as he arrived for what he apparently believed would be an ordinary work morning. He stood in the parking lot, briefcase in hand, when agents approached. According to agents present, he did not speak for more than a minute after being shown the warrant. Then he asked, quietly, if he could call his wife. The search of Mostagimi's office produced the item investigators had been most focused on, the internal ledger. not a digital file buried in encrypted storage, a physical book. A spiral-bound accounting journal, handwritten, with columns for date, transfer amount, originating entity, receiving account, and a final column labeled in Farsi script that translators later rendered as balance confirmed. 21 entries, the 7 confirmed transfers, and 14 additional transactions, some completed, some pending, documented with dates extending into July 2026. One entry, dated June 9th, 3 days before the warrants executed, documented a pending transfer of $640,000. The fifth-round payment prosecutors had identified as imminent. The transfer had not yet processed. Agents contacted the receiving bank that morning. A hold was placed. The $640,000 never cleared. The ledger also contained 2 entries that no investigator had previously identified. A payment of $88,000 processed in March 2026 to an account not associated with any of the 3 known Shell LLCs, and a payment of $124,000 in April 2026 to an account registered under a company name that, when cross-referenced with state records, did not appear to exist at all. Not in Texas, not in any other state database searched. Those 2 transactions remain under active investigation. The accounts have been frozen. The beneficial owners have not been publicly identified. That's the part of this case that doesn't appear in any press release. Investigators spent 3 days processing the seized digital evidence before the first full picture of the transaction network became visible. The server from the Manchester warehouse contained encrypted communication logs, the same encrypted messaging application Khalvati had used to coordinate with Rahimian. The encryption was intact. The keys were not on the seized devices. But the metadata, combined with the physical ledger, provided enough to reconstruct the operational timeline from the first contact in September 2025 through the morning of the arrests. The court filing unsealed in late June 2026 described the scheme in the government's language. A layered sanctions evasion network designed to provide material financial support to Iranian-linked shipping interests in violation of executive orders issued under IEEPA and the National Emergencies Act, with direct knowledge that the funds processed were intended to facilitate tanker fuel purchases for vessels subject to secondary sanctions under the 2026 Hormuz Strait designations. 3 defendants. Charges including conspiracy to violate IEEPA, money laundering, and, in Rahimian's case, making false statements to federal investigators stemming from a voluntary interview he had given in February 2026 when agents first made indirect contact under the guise of a routine Port of Houston compliance review. Rahimian had denied any knowledge of foreign origin wire transfers in that interview. The ledger entries from November 2025 through February 2026 contradicted that directly. Maximum exposure, 20 years. Prosecutors have indicated they will seek the guideline sentence. The case has been assigned to a judge in the Southern District of Texas who has presided over previous IEEPA prosecutions. What do you think? Did the regulatory framework fail by allowing 3 shell companies to be incorporated within 9 weeks with no meaningful verification of business activity? Or is the problem upstream in how foreign financial platforms are monitored before funds ever reach American banking rails? Drop your answer in the comments. It's not a simple question, and the people who study this for a living don't agree. The law firm that served as registered agent for all 3 LLCs has not been charged. In a statement issued through counsel, the firm said it conducted standard due diligence at the time of incorporation and had no knowledge of the intended use of the entities. That statement is under review by the State Bar of Texas. Khalvati's attorney has filed a motion arguing that, as a non-U.S. person who conducted no business activity on U.S. soil, his client falls outside IEEPA's jurisdictional reach. Federal prosecutors have filed a response arguing that the physical presence in the United States during the planning phase, combined with the deliberate use of U.S. registered entities and U.S. banking infrastructure, is sufficient for jurisdiction. The motion is pending. One detail stands out in reviewing all available public filings from this case. In Rahimian's February 2026 voluntary interview, the one where he denied knowledge of foreign wire transfers, he was asked a direct question about Al Nakheel Maritime Services. The interview transcript, partially reproduced in the warrant application, shows him responding that Al Nakheel was a long-time freight partner with whom he had done routine business for years. He was not wrong about that. What he omitted was the part where routine business had become a layering mechanism for $3, $1 million in sanctioned funds. That omission, small in the moment, catastrophic in retrospect, is the detail that makes this a useful case study in how financial crimes of this type are constructed. They don't require falsity throughout. They require truth in enough places that the falsity is invisible until someone looks at exactly the right transaction on exactly the right day. A compliance analyst did in December 2025 and filed a form. The network is dismantled. The fifth transfer was stopped. 3 defendants face federal prosecution in Houston's Southern District. The 14 transactions flagged for further review. The ones Mostagimi's ledger identified beyond the initial $4, $2 million, remain under active investigation. The 2 unidentified accounts from March and April 2026 are frozen but not attributed. Calvati's full communication network has not been publicly disclosed. And Al Nakhil Maritime Services continues to operate out of Muscat, pending a separate proceeding in Omani courts under a mutual legal assistance framework that, as of this writing, has produced no charges. The demand that created this network, the financial pressure campaign surrounding the 2026 Strait of Hormuz crisis, has not been resolved. The blockade continues. The financial evasion attempts will continue with it. The question isn't whether the next network will be built. It's whether the next SAR will find the right desk in 11 days or 111. If you've followed federal financial crime cases for any length of time, drop a comment. YES if you think shell company and corporation standards will tighten in the next 2 years as a direct result of cases like this, or no if you think the regulatory appetite isn't there. We read every one. Subscribe. The next case in this series involves a different type of sanctions evasion, a different region, and a financial architecture that makes this Houston network look straightforward by comparison.